and thanks everyone for joining this afternoon. As Sarah said, my name is Bill Oberkehr. I'm a project manager on the clean energy siting team at NYSERDA. Thanks again for joining everyone. I don't think this presentation is going to take the full hour, so there should be plenty of time for questions if folks have them at the end. I just want to give you a brief overview of what we're going to cover here. We're just going to start with laying the foundation for why all this is happening, with taking a look at New York State's clean energy goals. Then we're going to go into my team, the clean energy siting team, some of the resources and technical assistance that we offer. And then we're going to do just kind of a brief overview of the Article 10 process, and then move into an overview of the ORES process. So the reason that all of these things are kind of happening is New York State's energy policy. Our nearest goal is 70% renewable energy by 2030. And we want to have a completely carbon-free electric system 10 years later in 2040. So that, those goals are among the most ambitious, and at the time they were passed, they were the most ambitious in the nation. And among the most ambitious globally, actually. So we've got three main vehicles here. We've got the Clean Energy Standard, or the Renewable Energy Standard, the Climate Leadership and Community Protection Act, that you'll see as the CLCPA, or sometimes just referred to as the Climate Act. That's where we get these goals that you see over to the right, and that's really the all-encompassing legislation that passed in 2019 that lays the foundation for a lot of the work that folks at NYSERDA and in other agencies throughout the state are doing. And then finally, we have a Clean Energy Fund, which is a 10-year, $5 billion funding commitment. It's going to target energy efficiency, renewable energy, and energy innovation programs. So we're going to get a little bit of R&D in there. A little bit of building science type work with the energy efficiency, heating systems and all that great stuff, as well as renewable energy, which we will be focusing on today. The goal here is to reduce the cost of clean energy. This is kind of a successor program to other renewable energy, clean energy cost reduction efforts throughout the years in New York. We want to accelerate the adoption of energy efficiency to reduce load throughout the state. So that's going to be crucial to having this 100% carbon-free electric system by 2040. We need to be efficient to get there. And then we're going to obviously increase renewables to meet that load that remains. And we want to finally mobilize private investment in clean energy in addition to public sector efforts. So my team at NYSERDA is the Clean Energy Siting team. Folks on the webinar may be familiar with us to some degree or another. We have been traversing the state for years. And delivering a lot of webinars and attending town board meetings, planning board meetings, things of that nature for quite a while. So NYSERDA has created clean energy guidebooks to help local governments with managing renewable energy development in your communities. The Clean Energy Siting team is led by the New York Solar Guidebook and the New York Energy Storage System Guidebook. So that's the latter is going to be dealing with battery energy storage. There is also a wind guidebook for local governments that NYSERDA has developed outside of the Clean Energy Siting team. My team is here along with contractors that we have brought on board and will continue to bring on board to provide local governments free one-on-one technical assistance on the topics that you can see there. Property taxes and payment in lieu of taxes or pilots are very common technical assistance requests that we get. Zoning laws are another subject area that my team does a lot of work with. Municipal procurement, we still have a lot of folks And then, just kind of all things energy storage at this point. My team has been doing a lot of energy storage fire safety trainings, energy storage code trainings, things of that nature as well. So in the guidebook for solar for local governments, you can see the chapters here. We've really made a lot of this, simplified and very easy to understand. And it certainly was not necessarily before there was a solar guidebook. So this is a really valuable resource that local governments in New York, I think, are lucky to have. A lot of other states do not have anything this comprehensive to assist them with managing solar development in their communities. We've got a permanent inspecting chapter, which is going to include checklists for inspections. We also have a toolkit there, so jurisdictions can alter that checklist and make sure that any local laws by the jurisdiction are incorporated into these materials as well. The SECRA State Environmental Quality Review Guide and Guide to Understanding New York State's Real Property Tax Law, Section 487. That's the section of the property tax law that provides a tax exemption for certain energy systems. We also have a full toolkit for solar payment in lieu of taxes or pilots. That's going to include a pilot calculator and a property tax assessment calculator as well. Important to note with that resource that Department of Taxation and Finance did just publish their uniform standards for assessment of solar and wind projects, 1 megawatt or more. You can find that on Department of Tax and Finance's website. So when you're assessing these projects moving forward, it's going to be important to be cognizant of those regulations for projects over 1 megawatt. The solar energy local law addresses solar zoning. It's a template that municipalities can add certain information to and adopt, or they can tailor it to their specific needs of the community. And then decommissioning solar panel systems, that's an issue that we deal with frequently or that we hear about frequently. We have a whole chapter on that in the guidebook as well, with a lot of great detailed information. You can see in chapter 8, landowner considerations for solar land leases, stepping outside of the purview of local government a little bit. It's actually a resource that is more geared toward community members, folks who are interested or may become participating landowners in a large solar project. But that resource could also be useful for local governments as well, because we've seen throughout the state that often constituents will turn to their local government for help with that information. So we have a good resource for that right there in the guidebook. The battery energy storage guidebook, it's a little less developed. And mostly due to, there's just less energy storage in the state at this point than there is solar. The most recent addition to this was when the 2020 codes were adopted, the Uniform Fire Prevention and Building Codes. We pulled out everything that was relevant to energy storage in the residential code, the building code, the fire code, and the existing building code. And we put it in one resource, and that's chapter 4 of this energy storage guidebook. In addition to that, we have a battery energy storage model law, which addresses zoning for energy storage systems, very similar to the solar zoning law that I mentioned on the previous slide. We also have a model permit for energy storage, as well as the inspection checklist, which are also quite similar to the ones available for solar that I mentioned on the previous slide. So as I said, we do offer one-on-one technical assistance to local governments throughout the state, as well as trainings and some contractor support. So the way to reach us to kind of discuss your needs with us as a local government is to email cleanenergyhelp@nyserda.ny.gov. You can ask us a question, and we'll if we're not the right people to handle it, we can certainly get in touch with the folks who are, and we'll help out at no cost to the jurisdiction. And then for training and technical assistance opportunities, we have a link on the Clean Energy Siting for Local Government's homepage, and that will take you to a form that you can fill out. And finally, we do have an email list as well. Things like developments with that tax methodology, the standardized tax methodology for solar and wind that I talked about a bit earlier. We send out updates about that process and things of that nature through that email list. So if folks are in a position within their local government to be dealing with clean energy issues, it would probably be a good idea to sign up for that email list as well. So I want to get into another policy here. This is in addition to everything on the first slide that I went through in terms of New York energy policy. But what we have here is the Accelerated Renewable Energy Growth and Community Benefit Act that passed in I believe, April of 2020. So the components of this are three main components here. We've got the establishment of the Office of Renewable Energy Siting, or ORES, as it's typically called. Next, it establishes the Build Ready program at NYSERDA. So Clean Energy Resources Development Incentives Program has taken the name Build Ready at NYSERDA. And that consists of a team that looks at brownfield sites or Superfund sites throughout New York State and tries to secure the site, go through all the permitting and everything, and then bid those sites out to developers to make sure that we're siting on renewable energy on previously used and vacated industrial lands, because that is an ideal spot to be siting things like solar and energy storage. And then finally, the Accelerated Renewable Energy Growth and Community Benefit Act mandated a state power grid study and program, which the New York Power Authority took the lead on. The goals of the act were to advance renewable energy and drive statewide economic growth and create jobs, streamline the process for environmentally responsible and cost-effective siting of large-scale renewable energy projects across the state. So that's going to be primarily ORES, and establish tools for achieving the state mandate to obtain 70% of the state's electricity from renewable sources by 2030. As discussed in the earlier slide there. So that's really what this April 2020 Act is geared toward. And you see all of these three components are aimed to advance those goals. So of these components, since we are here to talk about Article 10 and ORES primarily, what we're going to focus on here is the Office of Renewable Energy Siting. That is ORES. If folks are interested in other components, please feel free to reach out to the Clean Energy Siting team. We can definitely get you a good amount of information on the Build Ready program and get you in touch with the right people for information on the state power grid study program. So, and to understand ORES and its impact, it's first important to understand the landscape for permitting solar energy systems and how ORES fits into that. So the permitting process is going to vary based on the size of the installation, and size of solar installations, for folks who may not know, is often talked about in terms of capacity. So capacity is watts, kilowatts, megawatts, gigawatts, and terawatts. A kilowatt is 1,000 watts, and megawatt is 1,000 kilowatts. Just so folks know the language. So for projects under 25 megawatts, those are going to be entirely permitted at the local level, but include a state environmental quality review, which is SEQR, and then any municipal requirements like any zoning laws for solar energy systems or energy storage, if that's part of the project as well, any other local requirements. These arrays are also going to be subject to the uniform codes. As I said before, the Uniform Fire Prevention and Building Code, that's state law. So that's going to apply to all projects throughout the state, with the exception of New York City. And then where home rule interacts with the uniform codes, for folks who don't know, is that municipalities can use those uniform codes as a baseline and only pass local laws that make the code more stringent. So that's how the uniform codes are going to work. And that is also going to hold true for projects greater than 25 megawatts in terms of the Uniform Fire Prevention and Building Code. But those projects are going to be permitted at the state level, whether through Article 10 or the Office of Renewable Energy Siting. We'll get into more detail about those throughout the webinar, so I'm not going to belabor that here. And then finally, we have projects in a bit of a gray area between 20 and 25 megawatts. They can either be permitted at the local level, or they can choose to opt in to the Office of Renewable Energy Siting process. So there's going to be a little bit of leeway for those projects in the 20 to 25 megawatt range. So let's start with Article 10, just going here in chronological order. So this was passed or this was established in 2011. So we've got, this is for large scale clean energy projects greater than 25 megawatts. And it's Public Service Law Article 10. Prior to 2017, there weren't that many solar projects that were larger than 25 megawatts, just because of some interconnection rules and other things. But since 2017 and the advent of NYSERDA's large-scale renewables program, there have been considerably more of those size projects in the pipeline. These processes for permitting projects that are greater than 25 megawatts are more relevant to solar these days than they have even 5 years ago, 6 years ago. So Article 10 was established to review and permit all major generation facilities, including both renewable and conventional energy facilities. So that's actually a key difference between Article 10 and the Office of Renewable Energy Siting. The Article 10 process was for gas generation or anything that was coming online above 25 megawatts. The Office of Renewable Energy Siting will not deal with any conventional generation. It will only be technologies deemed renewable by state requirements. To date, I actually just went through and updated this earlier this week, maybe Tuesday. So the Article 10 Siting Board has approved 14 projects. There's a pending queue that includes over 50 projects in addition to those 14 approved. And then 20 projects out of that 50 have either transferred or applied to transfer to the Office of Renewable Energy Siting process. So that's an option that they have as well. If projects had signed up or entered the Article 10 queue, the establishment of the Office of Renewable Energy Siting regulations allowed those projects to apply to transfer to ORES. I think a handful of projects have successfully transferred already, but most have just gotten their applications in to transfer to that process in 2021, so just this year. And then finally, we have the CLCPA, the Climate Leadership and Community Protection Act, passing in 2019, where we've got 11 years to get to 70% renewable energy. So, you see 14 projects to date since 2011, over 25 megawatts is, clearly, there was an issue with the process to be able to reach that ambitious climate goal by 2030 with the Article 10 process. So that kind of sets the stage for how the Office of Renewable Energy Siting and that process came into existence. You'll see the Article 10 process, or the Article 10 review right here, is actually very similar to the Office of Renewable Energy Siting process. So it'd be good if folks could kind of keep that in mind as we go through both, because there are some significant differences between the two, but conceptually, they are actually very similar. So first, we've got a pre-application phase, which is going to involve, in step one, a public involvement program. So that's where the applicant or the developer is going to introduce the project, identifies all the relevant stakeholders. So that's local governments, authorities having jurisdiction, community members, community groups, you know, so sometimes it's archaeological stakeholders, historic preservation committees. So this step is going to be the applicant identifying who all the stakeholders in the project are, and then they're going to set out a detailed plan for engaging all of those relevant parties. Second comes the preliminary scoping statement. So it's going to be a minimum of 150 days after filing the public involvement program in step one. The developer, the applicant, would submit this preliminary scoping statement, further detailing project description, perhaps including, you know, an early stage design of the project or environmental factors. Like a good one would be, you know, how this affects wildlife habitats or vegetation or prime farm soil, things of that nature. And then propose studies to evaluate those impacts, and where adverse impacts are found, propose mitigation strategies for those adverse impacts. So this pre-application stage is going to be where the intervenor funds kick in. That is something that has remained through the ORES process. Intervenor funds through ORES are $1,000 per megawatt, I believe. Oh, I'm sorry, that's the fee, the permitting fee for ORES. The intervenor funds, I don't believe, are set in stone for ORES, but that is one thing that is common between the two processes. And then within 60 days of the preliminary scoping statement filing, the developer is going to be able to initiate a stipulations process. So that's the pre-application. And then once those two steps are done, we're going to have an application, which we will then submit for review. So they're going to, the developer, the applicant, is going to submit this application to the Article 10 Siting Board, who will then determine whether or not the application is complete within 60 days, and then figure out how to allocate that those intervenor funds collected in the pre-application phase. Then finally, in the formal application phase, or next in the formal application phase, sorry, are the hearings, which consist of evidentiary and public statement hearings. There's a series of hearings held to obtain sworn testimony from experts, and then also this is where public input is built into the Article 10 review, and there's a similar component to ORES there as well. And then finally, we have the siting board decision on whether or not to permit the project. This must be issued within a year of the application being formally determined as complete. But as you can see, 14 projects since 2011 with 50 in the queue. That year timeline, you know, it's tough to get to that determination of completeness that triggers the year timeline. And I think that's also part of why the Renewable Energy Siting Office was created. I want to get into, so for solar and wind for 25 megawatts and above, Article 10 is you know, more or less the relic at this point, the old way of doing things. Now we've got this Office of Renewable Energy Siting. The process is also known as 94C. You may hear folks throughout the state use those two terms interchangeably, ORES and 94C. And the reason it's called 94C is because it's codified under Executive Law Section 94C. ORES is going to be the authority responsible for issuing permits for applicable renewable energy projects in consultation with relevant state agencies, and inclusive of all necessary approvals from a state and local perspective. Applicable projects include all renewable technologies that are equal to or larger than 25 megawatts in capacity. As I said before, new renewable projects between 20 and 25 megawatts may opt in to the ORES process. But if a project between 20 and 25 megawatts does not choose to opt in, then they will be subject to local permitting requirements and the state environmental quality review. Existing renewable projects in the early stages of Article 10 review may also opt into the ORES projects. And as I mentioned on a previous slide, to date, there are 20 projects who have either exercised this option or filed to exercise this option to go from Article 10 into ORES. So within 1 year of its creation, ORES adopted regulations and established uniform standards and conditions in consultation with several state agencies, including NYSERDA, the Department of Public Service, the Department of Environmental Conservation, and Ag and Markets. So that was a stipulation of the creation, is that these uniform standards and conditions had to be done within a year. So in August, so that's a year from April 2020, I should specify. In August 2020, a draft of those regulations were published for public comment and review. And then they were finalized in March 2021. As part of that process between draft and finalization, ORES was required by law to hold a series of public hearings on its regulations and uniform standards and conditions. They held 7 hearings and allowed for public comment through early December. Those hearings, just because they were in late 2020, were available via Zoom or maybe it was WebEx. And then in addition to that, they were held in person in, I believe, the 7 economic development regions in the state, if I'm remembering that correctly. So we've got a little more about ORES here. We're at a half hour now and I'm coming up to the end. So if folks have questions or are thinking of questions, now might be the time to finalize them. But you can see those ORES regulations at the website listed there. Or if you just go to ores.ny.gov, there's a menu bar with a navigation link straight to these regulations. They're about 150 pages long, and they provide great detail on what needs to be included in an ORES application. It's going to outline pre-application activities, which must occur at various times prior to the submission of an application, similar to an Article 10. And there are 3 major pre-application components. The applicant or the developer. Those terms are typically used interchangeably, and that's the renewable project developer. They must consult with the host municipality a minimum of 60 days prior to submission. So that means typically written notice to a town supervisor if it's a town, a mayor if it's a city or village, basically the leading executive in the jurisdiction. Needs to be notified in writing formally 60 days prior to, within 60 days prior to submission, minimum 60 days prior to submission rather. Then there's a consultation with affected community members. Affected community members is defined specifically within the ORES regulations. There are a number of different ways that you could be officially an affected community member, but this is just, so developers aren't only talking to local officials and folks with authority, they're also talking to the folks in the communities who will be affected by these projects. There's a similar time frame on that, a minimum of 60 days prior to the submission of the application. And then finally, prior to submitting an application, the applicant has to submit to ORES a draft of environmental and cultural reports as early as possible. So that's going to be very similar to what it was in Article 10. We're looking at habitat, we're looking at wetlands, we're looking at ag. For cultural, we're looking at, are there archaeological sites? Is it historic? Those types of things. It's indigenous land. So all of that needs to be submitted to ORES before the application. And then we have an outlined permit applications requirements, which includes a formal application supplemented by 25 detailed exhibits. Those 25 exhibits are explained in detail in the ORES regulations. Again, that's about 150 pages. If folks are particularly interested, I think it's worth at least skimming those regulations, they are broken up pretty well in terms of navigability into relevant subject areas. So it's worth taking the time, I think, to just look through if folks are interested in specifically what information ORES is collecting in their applications. So as I mentioned before, we've got requirements for developers to provide funding to ensure meaningful local participation. This is what was called the intervenor funds under Article 10. So it's going to be $1,000 a megawatt. As I said before, 75% of that is going to be reserved for local agencies. And then 25% of that is going to be reserved for qualified interveners. So that 25% qualified intervener would be, say there's not enough engineering expertise on staff in the local government. So we're going to bring in an engineering consultant, neutral third party, to review the project plans, the design. That engineering firm is going to be the qualified intervener, and things of that nature is what that 25% is going towards. And finally, within the ORES regulations, there are detailed requirements that are technology specific that include setbacks, height, noise, other considerations. So even if there is no zoning within a particular community, because in case folks don't know, not all communities in New York have zoning. And in order to have zoning at all, communities must have a comprehensive plan first, according to state law, or municipal law rather. So even if communities don't have zoning, the Office of Renewable Energy siting regulations have basically zoning built into them. But then if communities do have zoning, those laws will obviously be taken into account in the ORES process as well. I'm just going to give you kind of this at a glance view of what the ORES application steps are. We've got a received application, and that's after the pre-application steps that you see up here under bullet 1. So the consultation with the municipality and community members, that's all going to be before this timeline starts. We've got a received application within 60 days, again, similar to Article 10. There's going to be a determination of completeness of that application. And then within 60 days of that, so if the application is determined complete, within 60 days of that, a draft permit is issued. If the application is not determined complete, then ORES is going to kick it back to the applicant and tell them what they need to complete the application. When the application is deemed complete officially, a draft permit will be issued within 60 days. And then there's a minimum 60-day comment period after the draft permit is issued. So could likely be more than 60 days for comments for some projects, could be at 60 for other projects. And then at the end of the comment period, there's an adjudicatory process if necessary. So what would make an adjudicatory process necessary is if during the comment period, it comes up that there are local regulations that are significantly at odds with ORES regulations, and those are in conflict, there's going to be an adjudicatory process to just kind of rule on those details, to iron them out, and to just, it's an administrative law judge that's going to make that decision. And then within 1 year of the completeness determination, so going back to step 2 on this flowchart, final permit decision is issued. The word decision is crucial there. It's not that a final permit will be issued every time, it's that ORES has a year to decide whether or not they want to issue a permit. And again, that's to get at the issue where, between 2011 and 2021, in 10 years, we only had 14 projects done through Article 10. So that's why you see this timeline here under ORES. Once the application is deemed complete, we've got a year to make a decision one way or another to hopefully eliminate some of these barriers to developing these large projects. And then in the ORES process, the 94C process, we have opportunities for local engagement at every stage. And because this comes up wherever we go in New York to talk to folks about this, we figured it would be good to highlight those. So the first chance here for local engagement, for a permit application to be deemed complete, the applicant must demonstrate consultation with any municipality where the project is proposed to be located. So if you have a project, if I'm a developer and I have a project that's spanning 3 towns, I have to, at a minimum, consult with the chief executive in all 3 of those jurisdictions. And I have to consult with, I have to notify relevant community members in all 3 of those jurisdictions. So that's going to be step 1 for the local community to engage and kind of assert their values and make sure that the character of their community is protected. Then once we have a application that has been determined completed, the municipality will be notified on publishing of the draft permit and will provide feedback within the 60-day public comment period. So the municipality will indicate whether the proposed facility is compliant with applicable local laws and regulations. So there you have the opportunity for local zoning laws and anywhere that say the municipality has decided to make the uniform codes more stringent than what the state has adopted. This is your opportunity to get all of those considerations into the ORES process. So then finally, the municipality shall have access to intervenor funds made available to the applicant in the amount of $1,000 per megawatt, as I've said a couple of times now, in order to ensure that there is participation in this public comment period and that we can pull in the relevant experts who really understand things like system designs and secret processes and wetlands and all that great stuff that is involved with these projects. So
we have 3 questions, Bill, when you get a chance. Do you want me to read them to you, or?
I can do that. I actually just have 1 slide after this, and then I will get
okay.
to them.
Sorry.
No problem. And finally, should the municipality find the facility not in compliance with local laws and regulations, the application may proceed to that adjudicatory hearing process that I described before. That's where these issues are going before an administrative law judge. And finally, we've got, this is a part of why we're seeing projects over 25 megawatts. NYSERDA since 2017 has been issuing solicitations for the renewable attributes of large-scale renewable energy projects. Just in 2020, 22 projects were awarded. So that is different from the ORES process. The NYSERDA awards are just a contract to buy these renewable energy credits should the project get permitted and built. So NYSERDA entering into that purchasing contract has no bearing one way or the other on whether the project will eventually be permitted and built. So that's important to keep in mind. NYSERDA is not going to be the permitting entity, doesn't really have a whole lot to do with that, in fact, but NYSERDA is going to be buying a piece of the value of the power generated by these projects, and ORES is going to be the one doing the permitting and in control of whether or not they ultimately get built. But these LSR projects are really part of why we're seeing the proliferation of larger projects. And once again, we have our contact information. If folks have additional questions or needs, feel free to reach out to us, and I will take a look at your questions. First, where can I get a solar energy guidebook? You can find it on NYSERDA's website, but it's probably just easiest to just type into Google NYSERDA Solar Energy Guidebook. That's how I typically find it, if I'm being honest. It's just a quick direct link to get there. If you would like a hard copy of the Solar Energy Guidebook, you can go ahead and email cleanenergyhelp@nyserda.ny.gov, and we will work with our facilities folks in the office to get as many copies as you need mailed to you. Got another question here. Does the project applicant or the municipality have to opt into ORES process for the 25 megawatt? So the project applicant is the one who opts into the ORES process for that gray area between 20 and 25 megawatts. The municipality does not have a control over that. So that's going to be the developer of the project who is making the choice of whether they want to be permitted by SECRA and local standards or whether they want to opt into the state process, which also does take into consideration SECRA and local standards. And then I see one more question here. Who coordinates the timeline and filling out the forms for SECRA if a municipality does not have zoning? So zoning and SECRA are not inherently tied. SECRA is done by a lead agency, or what's called a lead agency. The lead agency can be designated by the municipality. It's typically going to be the town or the village that's going to do that. I think we've got DEC can be lead as well as other agencies. So there's not really a set in stone system for who must be lead agency. It is open to kind of project by project basis. We've got another question. What is NYSERDA doing to protect prime farmland and New York State farmland of interest? It's a great question. We've been working diligently with Ag and Markets over years now to come up with standards to protect those. I believe those standards are available through Department of Ag and Markets website. NYSERDA's templates, our zoning templates, all the information we provide have provisions in them aimed at protecting prime farmland and farmland of statewide importance. You'll see in our model zoning, we have thresholds that projects should not exceed this amount of X amount of farmland, which municipalities are able to tailor when they're looking at that law and looking to adopt it. So I think everything that NYSERDA does has a prime farmland and statewide importance considerations involved in it. That's really central to the work that we've been doing around solar, particularly for the past almost a decade, I believe, at this point. That is all of the questions that I see. I've got one. I have seen some local laws specifically say no large installations on prime or farmland of statewide importance. That is absolutely true. There are, I have seen those as well. There are plenty of local laws that say, the threshold for acceptable siting on prime or farmland of statewide importance is 0%. So that's one thing, and the template the template model law for zoning, as I said before, gives you a space where you as the municipality can do that.
Okay, are there any other questions for Bill? If not, I want to thank you very much for presenting to us today, Bill, and you have a good rest of the day.
You too. Thanks everyone for coming, and thank you, Sarah, for hosting.
Okay, we have one more question.
I'm sorry, I'm not seeing one more.
How safe are solar panels?
100% safe. There's no proof of radiation or really anything else. As far as we know, these aren't causing any sort of significant adverse environmental impacts. The one thing that has not been proven at this point is whether they can contribute or cause any sort of PFAS contamination. That just hasn't been studied, frankly. And there are you know, according to the materials that the Environmental Protection Agency and others have available on that issue, it seems like there are kind of more immediate things to study and to worry about with relation to PFAS than solar. But NYSERDA is working on doing a literature review of any available peer-reviewed material on that subject. And we're also working to do some testing on some sites as well. But as of right now, there really isn't good information out there on PFAS because in the grand scheme of things, it's a relatively new concern relating from a DuPont chemical factory in North Carolina.
That was, are you reading the chat?
Yes, I just pulled the chat back up.
Okay.
What will NYSERDA role be in decommissioning? Is a much understudied issue. I would disagree that it is understudied. NYSERDA will provide guidance on what your decommissioning parameters should look like, what considerations are there to any municipality who will ask, but a decommissioning clause will be part of that model law, that zoning law. So NYSERDA has a chapter in the guidebook on decommissioning considerations specifically. And then in addition to that, NYSERDA has language, template language in the model local law that says, you know, these are the parameters of what you should be thinking about for decommissioning and how you should word it in your zoning. And then in addition to that, we provide one-on-one technical assistance for free to anyone who asks if there are further concerns over and above the resources provided about decommissioning. There's one that says reviewing, these are more comments than questions. Regarding the peer-reviewed items, would you say it's hard because there are not any installations that are old enough? Asbestos seems likely a good idea way back when. Solar panels are not asbestos. There are no peer-reviewed items that we are aware of right now specifically relating to the relationship between solar panels and PFAS, which is per and polyfluoral alkylide substances. They're chemicals. The reason that we have not found any is the reason that that's currently an understudied issue is because there are thousands of different types of PFAS chemicals and they're everywhere. They're in food packaging, they are in car washes, they're in firefighting foams, there are thousands of them. As far as I know, solar panels have not kind of risen to that level of concern where they would be tested. But as I said, that's changing now. So NYSERDA is working on that. And I actually have a couple asks out at the Environmental Protection Agency to see if folks there are doing any work in that area as well. But right now it's an area that's just not well studied enough to make a determination one way or the other. But with one study done in New Hampshire, they tested 3 sites and there was no PFAS contamination or evidence of PFAS contamination at those sites. But they did not test for runoff and they did not test if there were PFAS in the solar panels in the first place, which I should say, most solar panels will not contain any PFAS materials in the first place. Where will the decommissioned panels be landfilled? That implies that decommissioned panels will be landfilled. They should be recycled and that recycling should be taken care of by the developer. You can put end-of-life responsibility into the decommissioning clause. It's perfectly fair to do that. When will NYSERDA put standards on the panels that will be used in the United States? I believe NYSERDA did that in around 2014. The standards just mirror California standards, which were in place before then and were thorough enough. So NYSERDA uses, for the NYSERDA program, uses those same standards. And then there are also standards on panels in the New York State uniform codes as well, that come from UL Underwriters Laboratory and other folks that are in the safety and fire safety business for electrical equipment.
Okay, thank you again, Bill.
Of course. Yeah, if any further questions, please feel free to reach out to cleanenergyhelp@nyserda.ny.gov. And thanks again, everyone, for coming.